He has to go to pretrial and his bond people.
How old are you?
I'm 21 now.
All right, so you're 21. Under the eyes of the law, you're an adult.
Yes, ma'am.
You need to be responsible for one. Today is going to be Zach's last day because he has too much trial experience. They're moving him to intake. So,
No, Judge.
I
won't go.
say nice. Be nice. Be kind to him. Wish him luck in intake and that he will enjoy it. I always say, room where you are planted. So we're going to miss you, Zach.
Absolutely. Thank you. I'll miss you too.
All right. Aw. Okay, docket is canceled. All right, so you're filing a motion to withdraw?
That is correct, Your Honor.
Why?
So our client is dissatisfied with the services he received. He's already discontinued payment of the retainer. He's seeking to terminate our services to seek out a new attorney, Your Honor.
All right.
And right out of the gate, the judge is already flagging accountability. Notice how she asks his age not to make conversation, but to remove any excuse later. Classic judicial move: establish adulthood, then hit them with responsibility.
So here's the court's issue with your motion to withdraw. How long have you been on this case?
Attorney of record was Anthony Wilson, Your Honor. I can't say exactly how many hearings he's had as the attorney of record.
Ms. Ferguson, when were they the attorney of record?
Seems like it was on March 15th of 2024.
All right, so we're going to start with what has been happening since you've been the attorney since March of 2024.
I was not the attorney of record, Your Honor.
Who was the attorney of record?
Anthony O'Neill Wilson.
All right.
And he was the one that was hired, but he's with his law firm. Am I correct?
That's correct. He's in the same law firm. So.
All right, so we're doing.
Okay, pause. Whenever a lawyer wants to withdraw, the court's antenna goes up. Judges hate last-minute attorney drama because it usually leads to delays, excuses, or strategic stalling. And guess what? This one's about to get messy.
Word salad here, but that's okay. Let me divide this salad up. So, April 1st, 2024, it was recalled for April 11th for a plea deadline date, and that was supposed to be the final plea deadline date. On April 11th, the plea deadline date was extended to April 15th because the defense counsel stated they were in Travis County. Even though Travis County starts with a T and not a B, that's where they were. April 15th, it was recalled to April 16th because defense attorney was no-show. April 16th, it was recalled to April 22nd, 2024 because the defense attorney was a no-show. On April 22nd, it was recalled for April 23rd for trial by Judge Angelini. Then on April 23rd, it was recalled again for April 24th by Judge Angelini for a jury trial. Then on July 9th, it was recalled for July 10th for jury trial. Then on July 15th, it was set for jury trial, September 9th, 2024 for impact court. Then on August 5th, it was set for a motion to withdraw by counsel and defense attorney was a no-show. Motion to withdraw is denied. Y'all need to be in impact for jury trial on September 9th. And they'll bring you overdressed for trial. They'll bring you overdressed in whatever clothing you have at the jail. If you wish to be attired in something different, then you'll need to make arrangements for with your attorney to do a clothing exchange. If there is an issue with the clothing exchange, let the court know, and the court will see if I can help you with that, expedited. All right, thank you.
And you know, if I may, as Anthony O'Neill Wilson is the attorney of record,
This is where things go from confusing to chaotic. The judge isn't just annoyed, she's about to unload a full chronological breakdown of missed hearings, no-shows, and delays. When a judge starts reading dates like a receipts list, someone's in trouble.
no one other than him has access to discovery. He's poorly handled this case. There is no record of him actually ever downloading discovery. It's not like it's in the client's file. Since we're going to be held onto this case, I do ask that it be expedited to put me as attorney of record so I get access to discovery as soon as possible, as early as today.
Right, and my understanding is that your firm He was with your firm, correct?
Yes.
All right. So, Ms. Ferguson, just make sure that his name is there. But I will tell you, since your firm is listed as the firm, your firm should have access to the discovery. But if you're saying your firm doesn't, which I find that hard to believe, since the previous attorney was a member of your firm, we will make sure that that happens. But a motion for continuance will not be granted because your firm is saying it does not have discovery when your firm should have discovery because you have a firm. The attorneys work underneath the umbrella of that firm, and all that discovery should be there. All right, thank you. Is there anything else? Thank you.
Thank you.
Hello, how are you doing? Yes.
It's a lovely day, Judge.
That's all right. We have a violation report. Your client missed a setting, well, an appointment with pretrial services.
Yes, Your Honor. I tried to contact him.
Everyone, will you all please whisper? But if you're not going to whisper, bring that same level of tone when you're before the bench so I can hear you. Yes.
I finally was, the numbers that we had, that the pretrial had was his mother's telephone number. She works. I was able to call early enough yesterday that I finally got a hold of her. Apparently, Mr. Vasquez was not staying at the home. Are you staying somewhere else?
No, you, sir.
Yes. So I don't know if she didn't understand who the numbers were. He's been reporting to his bonds person. Nobody ever told him. Your Honor, I would ask that he be allowed to go now that he understands he has to go to pretrial and his bond people.
How old are you?
I'm 21 now.
All right, so you're 21. Under the eyes of the law, you're an adult.
Yes, ma'am.
You need to be responsible for one, your own case, as far as showing up. Just, I don't know why. And when I was a defense attorney too, people would say, well, my bondsman never told me. Well, your bondsman will not be going to jail if you don't show up. Do you understand?
Yes.
So with this pretrial services, you need to be in contact with them. Do you understand?
Yes.
All right, just have a seat. Ms. Ferguson, can you have his pretrial services officer zoom in? We're going to have his officer zoom in so they can have all of your contact information. Do you understand?
Yes, ma'am.
All right, so just have a seat.
May I be excused, Your Honor?
Yes.
Thank you. You don't need me for that.
Attorney on Johnny Ruiz Jr., I think it's criminal trial division, collision involving death. Yes. All right, so I know there are probably still some outstanding discovery. Can someone tell me what's maybe outstanding? Do you have all of the medical? Do you have the autopsy?
I do, Judge.
All right, is there anything that's outstanding?
Not that I'm aware of at this time.
All right, so this is what I'm going to do. This is a first setting case. I'm going to set it in 30 days for you to make sure that you have all of the discovery. And then on that day, if you have all the discovery, I'm going to want an acknowledgement of discovery.
Understood.
All right, Ms. Ferguson, I need a 30-day reset on Johnny Ruiz. State you're excused.
September 30th.
All right, we're going to come back on September 30th.
Here comes the good part, discovery drama. For those new to court lingo, discovery is all the evidence attorneys must review before trial. If an attorney never downloaded it, that's basically going into a gunfight with no ammo.
All right, Mr. Ruiz, when you come back to court, no t-shirts, you understand?
Yes, I saw the last one. I do apologize. I'm nervous and I just wanted to feel comfortable.
Oh, no problem. Here's the thing, unless somebody tells you what you don't know it, right? And so I always tell people it doesn't have to be a three-piece suit, right? Because I don't have a three-piece suit hanging in the closet, although I would like one, but I don't have one hanging in the closet. So,
Understandable.
all right. So once you sign the reset form, you're excused. So what's going to happen? We're going to come back on September 30th.
Mhm.
On that date, your attorney is going to let me know if he has all of the discovery. If he doesn't, hypothetically, let's say he's missing a medical report. He'll let me know he's missing a medical report. Then we'll give a reset date for him to make sure he has that, and the state turns it over. I want to make sure that he has all of the discovery so we can proceed.
Yes, ma'am.
All right. Do you have any questions about the process or anything?
Mhm.
All right. Just take a seat. They're going to give you a reset form. And once you sign it, you're excused. And make sure you put your email if you have one on the reset form. Okay.
Yes, ma'am.
All right. Thank you.
Thank you, Your Honor.
And to think You almost were going to leave this case. See, attorneys do work hard. You understand?
Yes, ma'am.
And I still remember you maybe not wanting to speak to your attorney.
We got off on the bad foot.
Well, I mean, you got off on the back.
I did, yes.
Yes. All right. So the state has filed a motion to dismiss for further investigation. What that means is maybe it's going to come back, maybe not. I don't know. You understand? Defense, you have no objections to the court signing the dismissal?
No, you're not.
Small detail, big meaning. Clothing in court doesn't win cases, but it does influence the judge's first impression. And trust me, judges remember. So when she brings up the t-shirt? That's a soft but firm reminder, respect the room.
All right. You know what happened to cause you to be in this situation? Whatever happened, don't let it happen again. Because
ma'am.
this case, 5 to 99 years your life. Okay?
Yes, ma'am.
All right, here you go, counsel.
Maybe excuse, Judge.
Yes.
Thank you. Thank you.
Salina?
And this is the moment where the tone shifts. The judge goes from procedural to personal. This is a warning wrapped in compassion. When a judge mentions the sentencing range out loud, that's their way of saying, you're lucky. Don't roll those dice again.